Fair Labor Standards Act, or FLSA, is administered by the Wage and Hour Division of the Department of Labor. The Act establishes standards for minimum wage, overtime pay, record keeping, and child labor. These standards affect more than 130 million workers, both full and part-time, in both the private and public sectors. The Fair Labor Standards Act is a U.S. federal law enacted in 1938 to prohibit employers from taking advantage of employees. It includes provisions which prohibit child labor, set a minimum wage, require overtime pay, require equal pay, which prohibits sex-based wage differentials, and requires record keeping. The FLSA requires that most employees in the United States be paid at least the federal minimum wage for all hours worked and overtime pay at 1.5 regular rate of pay for all hours worked over 40 in a work week. The federal minimum wage is $7.25 per hour, effective July 24, 2009. Many states also have minimum wage laws. Some state laws provide greater employee protections, and employers must comply with both. For instance, in the state of Minnesota, effective August 1, 2016, the minimum wage is $9.50 per hour for large employers. The law requires that employees be paid overtime for hours worked at a rate of 1.5 times the regular rate of pay unless the employee is exempt from the provision. Overtime is defined as more than 40 hours worked in a work week. Significant time and attendance record keeping is necessary for compliance for overtime. As mentioned, the exemptions provided by the FLSA Section 13 apply only to white-collar employees who meet salary and duties tests set forth by Part 541 regulations. The exemptions do not apply to manual laborers or other blue-collar workers who perform work involving repetitive operations with their hands, physical skill, and energy. FLSA covered non-management employees in production, maintenance, construction, and similar occupations such as carpenters, electricians, mechanics, plumbers, iron workers, craftsmen, operating engineers. Construction workers and laborers are entitled to minimum wage and overtime premium pay under the FLSA and are not exempt under Part 541 regulations, no matter how highly paid they might be. The FLSA is an employee protection act whereby employees are generally presumed not exempt and entitled to overtime pay. However, there are exemptions from this law for executive, administrative, professional, and computer and outside sales employees. Employees may be exempt from overtime provisions if they meet 3 tests in regards to first, salary level, second, salary basis, and third, job duties. Let's take a look at each. Test number 1, salary level. The employee must be paid at least $455 per week or $23,660 annually. These amounts are actual payments, and salary should not be prorated for part-time employees. Effective December 1, 2016, the salary level threshold increases to $913 per week or $47,476 per year. Test number 2, salary basis. An employee must receive a predetermined fixed salary that's not subject to reduction due to variations in quality or quantity of work performed, except for some very narrow specified circumstances. And finally, test number 3, job duties. Employees must meet all of the criteria specified in one or more of the following exemptions: the administrative, executive, professional, computer, or outside sales exemptions. Highly compensated employees performing office or non-manual work and paid a total annual compensation of $100,000 or more, which must include at least $455 per week paid on a salary or fee basis, are exempt from the FLSA if they customarily and regularly perform at least one or more of the duties of an exempt executive, administrative, or professional employee identified in the standard tests for exemptions. The term primary duty is used throughout each of the exemptions. The definition of primary duty is the principal, main, or major, or most important duty that the employee performs. Determination of primary duty must be based on the character of the employee's job as a whole. Factors to consider when determining primary duty include the relative importance of the exempt duties as compared with the other types of duties, the amount of time spent performing the work. Not more than 20% of the employee's time may be spent on non-exempt work, the employee's relative freedom from direct supervision, and the relationship between the employee's salary and wages paid to other employees for the kind of non-exempt work performed by the employee. Employees who spend more than 80% of their time performing exempt work will generally satisfy the primary duty requirement. In order for an employee to be considered exempt as an executive, all of the three criteria must be met. First, primary duty of managing the enterprise or customarily recognized department or subdivision. Managing includes such activities as interviewing, selecting, training, and disciplining employees, setting and adjusting pay and work hours, and planning and appropriating work, among many others as identified in law. Number 2, customarily and regularly direct the work of at least 2 plus full-time employees, or FTEs. Third and finally, hires or fires employees, or whose recommendations as to hiring, firing, advancement, promotion, or any other status change of employment are given particular weight. Generally, an executive's recommendations must pertain to employees whom the executive customarily and regularly directs. It does not include occasional suggestions. An employee's recommendation may still be deemed to have particular weight, even though the higher-level manager's recommendation has more importance, and even if the employee does not have the authority to make the ultimate decision as to the employee's change in status. A common question that arises under the executive exemption is how to classify employees who perform both exempt management duties and non-exempt duties. The regulations state that a manager who performs both exempt and non-exempt work at the same time is not automatically disqualified from the executive exemption. Generally, the exempt executives themselves make the decision regarding when to perform non-exempt duties. In contrast, the non-exempt employee generally is directed by a supervisor to perform the exempt work or performs the exempt work for defined periods of time. For example, if an assistant manager's primary duty is management, performing work such as serving customers, cooking food, stocking shelves, and cleaning the establishment does not preclude the exemption, as an assistant manager can supervise employees and serve customers at the same time without losing the exemption. In contrast, a relief supervisor or working supervisor whose primary duty is performing non-exempt work on the production line in a manufacturing plant does not become exempt because he or she occasionally has some responsibility for directing the work of other non-exempt production line employees when, for example, the exempt supervisor is on vacation. Department or subdivision. The phrase, a customarily recognized department or subdivision, is intended to distinguish between a mere collection of employees assigned from time to time to a specific job or series of jobs and unit within permit status and function. The phrase customarily and regularly means greater than, occasional, but less than consistent. It includes work normally done every work week, but does not include isolated or one-time tasks. The phrase 2 or more other employees means 2 full-time employees or their equivalent. For example, 1 full-time and 2 half-time employees are equivalent to 2 FTEs. The supervision can be distributed among 2, 3 or more employees, but each such employee must customarily and regularly direct the work of 2 or more full-time employees or equivalent. For example, a department with 5 full-time non-exempt workers may have up to 2 exempt supervisors if each supervisor directs the work of 2 of those workers. Particular weight. Factors to be considered in determining whether an employee's recommendations as to hiring, firing, advancement, promotion, or any other status change have particular weight included but are not limited to whether it is part of the employee's job duties to make such recommendations, and the frequency in which such recommendations are made, requested, or relied upon. Generally, an executive's recommendation must pertain to employees whom the executive customarily and regularly directs. It does not include occasional suggestions. An employee's recommendation may still be deemed to have particular weight, even if a higher-level manager's recommendation has more importance, and even if the employee does not have the authority to make the ultimate decision as to the employee's change in status. Now to the administrative job duties test. In order for an employee to be considered exempt as an administrative employee, both of the two following criteria must be met. 1. The employee's primary duty must be the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers, and the employee's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. To meet the directly related to the management or other general business operations requirement, an employee must perform work directly related to assisting with the running or servicing of the business. Work directly related to management or general business operations includes, but is not limited to, functional areas such as tax, accounting, budgeting, quality, marketing, human resources, benefits, compliance, information technology, purchasing, safety, and public relations, among others. Employees' customers. An employee may qualify for the administrative exemption if the employee's primary duty is performance of work directly related to the management or general business operations of the employer's customers. Thus, employees acting as advisors or consultants to their employer's clients or customers, such as tax experts or financial consultants, for example, may be exempt. Discretion and independent judgment. In general, the exercise of discretion and independent judgment involves the comparison and the evaluation of possible courses of conduct and acting or making a decision after the various possibilities have been considered. The term must be applied in light of all the facts involved in the employee's particular employment situation and implies the employee has the authority to make an independent choice free from immediate direction or supervision. Factors to consider include, but are not limited to, whether the employee has the authority to formulate, affect, interpret, or implement management policies and operating practices, whether the employee carries out major assignments in conducting the operations of the business, whether the employee performs work that affects business operations to a substantial degree, whether the employee has the authority to commit the employers in matters that have significant financial impact, and whether the employee has the authority to waive or deviate from established policies or procedures without approval. The fact that the employee's decisions are revised or reversed after review does not mean the employee is not exercising discretion and independent judgment. The exercise of discretion and independent judgment must be more than the use of a skill in applying well-established techniques, procedures, or specific standards described in manuals or other sources. Discretion and independent judgment does not include applying well-established techniques, policies, or procedures, clerical work, recording or tabulating data, or performing mechanical, repetitive, or recurrent or routine work. The term matters of significance refers to the level of importance or consequence of the work performed. An employee does not exercise discretion and independent judgment with respect to matters of significance merely because the employer will experience financial losses if the employee fails to perform the job properly. Similarly, an employee who operates very expensive equipment does not exercise discretion and independent judgment with respect to matters of significance merely because improper performance of the employee's duties might cause serious financial loss to the employer. There are two types of exempt professional employees: learned professionals and creative professionals. The specific requirements for exemption as a bona fide professional employee are summarized next. To qualify for the learned professional employee exemption, the following must be met. First, the employee's primary duty must be the performance of work requiring advanced knowledge. The advanced knowledge must be in a field of science or learning, and the advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. Work requiring advanced knowledge means work which is predominantly intellectual in character and which includes work requiring consistent exercise of discretion and judgment. Professional work is therefore distinguished from work involving routine, mental, manual, mechanical, or physical work. A professional employee generally uses advanced knowledge to analyze, interpret, or make decisions from various facts or circumstances. Advanced knowledge cannot be attained at the high school level. Fields of science or learning include law, medicine, theology, accounting, actuarial computation, engineering, architecture, teaching, and various types of physical, chemical, and biological sciences, pharmacy, and other occupations that have a recognized professional status that are distinguishable from mechanical arts or skilled trades where the knowledge could be a fairly advanced type, but not in a field of science or learning. The learned professional exemption is restricted to professionals where specialized academic training is a standard prerequisite for entrance into the profession. The best evidence of meeting this requirement is having the appropriate academic degree. However, the word customarily means that the exemption may be available to employees in such professions who have substantially the same knowledge level and perform substantially the same work as a degreed employee, but who have attained the advanced knowledge through a combination of work experience and intellectual instruction. This exemption does not apply to occupations in which most employees acquire their skill by experience rather than by advanced, specialized intellectual instruction. To qualify for the creative professional employee exemption, all of the following tests must be met. The employee's primary duty must be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. Invention, imagination, originality, or talent distinguishes the creative professional from the work primarily depending on intelligence, diligence, and accuracy. Exemption as a creative professional depends on the extent of the invention, imagination, originality, or talent exercised by the employee. Whether the exemption applies, therefore, must be determined on a case-by-case basis. The requirements are generally met by actors, musicians, composers, soloists, certain painters, writers, cartoonists, essayists, novelists, and others set forth by the regulations. Journalists may also satisfy this duty requirement. A recognized field of artistic or creative endeavor includes fields such as, for example, music, writing, acting, or the graphic arts. Teachers are exempt if their primary duty is teaching, tutoring, instructing, or lecturing in the activity of implementing knowledge, and if they're employed and engaged in this activity as a teacher in an educational establishment. Exempt teachers include, but are not limited to, regular academic teachers, kindergarten or nursery school teachers, teachers of gifted or disabled children, teachers of semi-skilled trades and occupations, teachers engaged in automotive driving instruction, aircraft flight instructors, home economics teachers, and vocal or instrument music teachers. The salary and salary basis requirements do not apply to bona fide teachers. That is, the only test that must be passed is this job duties test. An employee holding a valid license or certificate pertaining to the practice of law or medicine is exempt if the employee is actually engaged in such practice. An employee who holds the requisite academic degree for the general practice of medicine is also exempt if he or she is engaged in an internship or resident program for the profession. The salary and salary basis requirements do not apply to bona fide practitioners of law or medicine. To qualify for the computer exemption, the following must be met. The employee must be employed as a computer systems analyst, programmer, software engineer, or other similarly skilled worker in the computer field performing the duties described in regulations. And the employee's primary duty must consist of the application of systems and analysis techniques and procedures, including consulting with users, the design, development, documentation, analysis, creation, testing, or modification of computer systems, or the design, documentation, testing, creation, and modification of systems related to machine operating systems, and or a combination of the aforementioned duties and regulation. To qualify for the outside sales employee exemption, all of the following tests must be met. The employee's primary duty must be making sales as defined in the FLSA, or obtaining orders or contracts for services or for the use of facilities for which consideration will be paid to the client or customer, and the employee must be customarily and regularly engaged away from the employer's place of business. An outside sales employee makes sales at the customer's place of business, or if selling door to door at the customer's home. Outside sales does not include sales by mail, telephone, or the internet. Any fixed site, whether home or office, used by a salesperson as a headquarters or for solicitation of sales is considered one of the employer's places of business, even though the employer is not in any way at the formal sense of that site. So that was your salary level, basis, and all of the job duties tests set forth by regulation. The FLSA provides minimum standards that may be exceeded but cannot be waived or reduced. When state laws differ from the federal FLSA, an employer must comply with the standard most protective to employees. Links to your state labor department can be found at www.dol.gov.